Estamos fechando um ciclo de uma semana em que nós tivemos a discussão de vários temas relacionados ao direito concorrencial, direito antitruste no Brasil e no mundo, graças à vinda da professora Magali Eben, que está aqui do meu lado, professora da Universidade de Glasgow, que tem feito um trabalho que é referência no mundo todo, e nos presenteou com a sua vinda. Então, nesse momento, eu tenho que agradecer, em primeiro lugar, o Departamento de Direito Público da Universidade de São Paulo, campus Ribeirão Preto, pelo apoio que foi dado para a realização dessa semana, que basicamente pôde disseminar para muitos estudantes da nossa casa e também para toda a comunidade jurídica diversos temas que estão na ordem do dia relacionados ao direito concorrencial. Além disso, nós estamos fechando aqui, né, a semana com a realização do Seminário Internacional de Direito Econômico para a sua 5ª edição, né, então voltamos a tê-lo, né, o período que eu fiquei afastada da universidade, ele acabou não sendo realizado, então uma alegria poder também, com a vinda da professora, ter esse momento para um debate que eu acho que vai ser muito produtivo. Nós temos aqui a professora Magali, foi muito colaborativa essa semana toda, e também colocou para nós um desafio grande, que é debater um texto dela que sequer ainda foi publicado, né? Então, nós estamos aqui colaborando, né, e tivemos em primeira mão, os professores tiveram acesso em primeira mão o artigo para poder debater com vocês aqui hoje. Eu vou mudar logo mais para o inglês, né? Então, estou aqui compartilhando com todos a nossa alegria de ter conseguido, né, fazer essa semana interinstitucional. Então, tenho aqui que agradecer também os nossos parceiros, a FGV Rio, a FGV São Paulo, o Mackenzie, o IDP, a ASCOLA. A Magali também tem feito um trabalho muito importante dentro da Academic Society for Competition Law, que eu também participo, né, e aqui no Brasil, junto com o professor Vicente Bagnoli, nós estamos à frente do capítulo brasileiro. A nossa básica função é disseminar o direito concorrencial. Aqui na faculdade, vocês têm essa disciplina como disciplina obrigatória, mas vocês são uma gota dentro de um oceano. E isso é para realmente ser considerado como um diferencial, considerando, inclusive, acho que vocês estão acompanhando as notícias no mundo, todas que têm relação também com o direito concorrencial. Quando nós falamos das big techs hoje, das grandes empresas de tecnologia, quem não entende direito concorrencial não entende a discussão. Então, vocês, como acadêmicos dessa instituição, estão a par desses temas e eu espero realmente que essa disciplina continue na nossa grade, como foi a luta no passado para que ela estivesse hoje. So, I'm going to switch into English. I'm super happy to have you here, Magali. I know it was a very intense week for us, okay, especially for you. So everybody here is very impressed about the beauty of this campus and the university. But the best thing that we have here, in fact, are our students. And I'm super glad that they are here, besides the fact that I have here great friends that are brilliant professors, like Professora Patrícia Sampaio from FGV Rio, Professor Vinícius Klein, da Federal do Paraná, and Professor Nicolo Zingales, the FGV Rio. Nicolo, in fact, was participating from one of the conferences that we had before the pandemic. At that time, he was teaching at Leeds, and now I can have you here. So it's I really appreciate the fact that you are now here in presence. Thank you so much for your presence. So Magali, you have a presentation about market definition and legitimacy. We are very curious about it. You're gonna debate a lot your paper, so the floor is yours.
Hi everyone, thank you for coming in the morning to listen to me speak. I know that it's quite a feat to get people in a room to listen to you, so I really appreciate it. I am very happy to be here, and in Brazil in general has been great, but here is great as well. It's nice to actually see students. I realize that for you, the vacation has only just ended, so thank you. So my name is Magali Eben. I am at the University of Glasgow in Scotland, in the United Kingdom. And I work on several things, all related to competition law. But my first love was market definition. And so I tend to come back to this concept of the market and why we need to look at markets and identify markets in competition law settings whenever I can, whenever I don't have to do something else. And so I today will present a paper which I'm hoping that my friends and colleagues here will constructively but critically tear apart. And so I will give you a little bit of a really brief overview of what the paper is about, and then I will hopefully get a lot of comments. So I started my trajectory in competition law with a PhD on market definition, which Nicola was on my panel. So it's we're coming back to the similar topic again. And throughout the PhD, really, I was trying to explain what the problem was with what is a market when you talk about digital products, so products offered by Facebook or Google. But the whole time throughout, there was a discussion about whether we even needed to identify markets in competition law setting. And I keep coming back to it, and this is part of this bigger question. I don't know how many of you have done a lot of competition law, but one of the basics, but also most controversial concepts now is a market. Mm-hmm. Yeah, thank you. Oh. Blackout. Okay, perfect, thank you. So, one of the most basic concepts is a market, right? So at the start of competition cases, you very often will identify what the market is in which the companies that you're investigating operate. And this market concept is one we find in competition law, but also obviously a concept which you see throughout other laws and regulations, this idea of the market. Now, there has for a long time been a debate about whether we even need to define a market in competition cases. And I want to come back to this, and I want to say that I think you need to define a market in competition cases for a variety of reasons. One of which is that we are currently in Europe, but I think throughout the world, at a position where we're starting to kind of blur what the limit is of competition law versus other laws. So, for example, in the European context, there are now cases that use violations of data protection law and privacy to find that there is an infringement of competition law. And one of the arguments I want to put forward is that in order to understand the difference between data protection law and competition law, which may use data protection law, the market is quite an important concept. But if we take a step back, why was there so much criticism or doubt about market definition in the first place? Well, there's two main reasons. The first is that it's very difficult, or it was very difficult, to figure out what markets are for digital services. There were methodological problems because our tools of market definition were really created in a context of physical products for which you pay money, and the relationship is most of the time relatively direct between a seller and a buyer. In digital markets, things became a bit more complicated. You could have multiple products or services without physical boundaries that were interrelated, but also that were sold to consumers, not for money, not for a monetary price, but in exchange for something else, in exchange for your data or your attention. And that didn't fit very well in our initial tools. So some of the opposition against identifying markets was really about methodology. How do you identify markets in these new contexts? A second issue, and the methodological challenges, I think, are not such a big problem, right? You just have to find new methods. Although that's easier said than done. It's not that easy to find new methods. But I think fundamentally, methodological challenges we can handle. But then there were more existential questions. So there were people saying that you shouldn't identify markets because what you really need in a competition case is to find out whether a company has market power, and you should just find that directly. You should just identify whether a company has market power without needing to look at whether there is a market. For those of you who are relatively new to this, the way in most competition cases we find market power is by first identifying the market and then figuring out how much of a proportion, a share of that market a company has. So how much of the share of sales or the share of revenue does a company have? But there were people who said you can just directly find market power by looking at the difference between the price and the cost. Basically, an economic tool to find market power. And a lot of people liked this discussion, and I think it is fundamentally wrong. I think it misses the point, and this is what I'm trying to say, that the market isn't just about market power. And it should be an important element of competition cases because it's about more than market power. There are two things that I think market definition do or are important for. Juliana, you have the, oh, no? Okay, never mind. I was gonna say you have the magic touch, but apparently not. Can you go back one? Perfect, thank you. So there are two things that I think market definition is important for. The first, I have written a published paper about. The second, I am going to present here. It's a draft paper, so I really it's a work in progress, so I want as much feedback as I can. The first is that the market is a useful tool in order to understand the setting, the context of a case. So you need to understand who the players are, what their interactions are, and the characteristics of the activities you're looking at, to understand the conduct that you're investigating, but also to understand the potential for that conduct to cause harm. So that's the first. The market is useful because it creates boundaries, a forum. The second is that I think that without a market, a reference to a market in a case, the enforcement of competition law cannot be legitimate. And that's what I want to focus on. But I want to take a second to talk a little bit about this first idea, that the market is a useful working concept. So I wrote a paper which has had mixed reception. Some people love it, a lot of people hate it. But I enjoyed writing it, so I think that's all that matters. And in it, really, I wrote this paper because I couldn't sleep at night. And I was listening to an audiobook by Carlo Rovelli, who basically talks, he's really cool, but he was talking about how reality didn't exist. And so there was this quote in the book where he says that, basically in a nutshell, he says that human beings look at the physical world and organize it into artificial groups, because this is the only way the human brain can work and can handle things. And so I woke up at night, took this quote, and I started writing a paper about market definition. And for the next 3 or 4 nights, I wrote at night because I couldn't sleep. Maybe that's why people hate it, because it's like a paper written in the middle of the night. But the main point I was trying to make is that people really have too much faith in our ability to create something objective and robust that is called market definition. So if we take a step back, a lot of people were criticizing market definition because they said that there was a level of almost arbitrariness, almost ad hocness, where in different cases we had different markets. Some people I really respect were saying, how can you say that we are doing a scientific analysis when every case for the same company, the market is different? And they were trying to say you need the same market for the same companies throughout different cases in order to increase objectivity and legal certainty. And I tried to write the paper to tell them that they're fundamentally misunderstanding what market definition is and how you can get to legal certainty in the process of market definition. Just like, what is a popular Brazilian mountain? A mountain. Yes, give me an... Pico de Itajaí?
Pico da Bandeira.
Okay, take any one of them, okay? It's very artificial that we call a particular construction of rocks a mountain, right? Well, I was trying to make the analogy that it's the same kind of level of artificiality we use in looking at which economic activities are a market. And we choose which economic activities we group together as a market because they allow us to investigate one single case, one single conduct, and one single theory of harm. And so you're never going to have the same market for the same company in different cases because the conduct is different, the theory of harm is different. And so that article was trying to say the market is a working concept. It's there to help the analysis. It's not some kind of, ultimate truth. So that's the first concept that I was working with. You need a market because it helps you artificially put things together that you need to look at together in order to come up with an answer. And then in the first article, I explain how I think we can do this with a little bit more objectivity and legal certainty. The next step now that I'm trying to put forward is that doing that, having this reference to a market, not only allows you to kind of put things together in a box so you could look at them more easily, but also allows you to put forward a case, an analysis, which is legitimate, which citizens and businesses can look at and say, okay, I understand why you're doing what you're doing. There are two things that I think are important here. First, the question, was it even appropriate for competition law to be applied to a particular activity? That's the first question. And the second question is, why competition law? Why not another area of law? And I think the market can play an important practical role here in ensuring the answer is yes, competition law was appropriate, and yes, it was better to apply competition law than another area of law. So that's what I try to do in this draft paper. And so the fundamental first assumption I make is that it is better to have a public authority intervene than to let individual companies work things out themselves. So this is the starting assumption. I'm not to engage in a debate about whether or not we should let the market self-regulate. That's another conversation. My first assumption here is it was appropriate for government legislators, someone to intervene, because there is what we call a coordination problem. So where you don't trust that individual companies, people will be able to make decisions that are in the public interest. And so you need to have a public authority that comes in and intervenes to make sure that the economy works in the public interest. When you make that assumption, you still have to ask, well, is it legitimate for competition law to apply? And what is the boundary with other areas of law? And I think this is a really important question at a time where we have competence creep. So competence creep, as I said before, is when a competition authority decides that other laws aren't being enforced properly and will enforce them themselves. And I think there can be moments where competition law is applied wrongly, where really it isn't an issue about the market, but it's an issue about individual rights. And I want to try to make that difference and say that competition law is about protecting the collective interest, not about protecting individual interests. And the market, using the market, defining a market in a case, really illustrates that this is about the collective interest rather than about individual interests. I think when you are looking at competition law, it's a type of regulation, it's a type of intervention that fixes market failures. But there are a lot of interventions by law and policy that fix market failures. So the question is, what makes competition law different? And so this is a question that in Europe is not resolved yet. And a lot of people say that in order to know which law to apply, you need to look at the objectives of the law. And in a way, that's what I'm doing. But I want to make it more practical. We have had a debate about what the objectives of competition law are and how they are different from other laws for a very long time, for decades. And we ultimately, even when we agree for like 5 or 10 years what the objectives of competition law are, we ultimately don't have a very easy tool to actually, in a case, prove that we are implementing competition law for the objectives that we agree on. And to me, having something like the market is the way that we could make that difference. Okay. So the idea that markets represent the collective interest is really the key point of the article. And it's not so straightforward, I think, why this isn't true for something like consumer welfare or total welfare. But most areas of law that regulate markets have some kind of economic objective of efficiency or welfare. But the way they get there is different. In the paper, which is still in a draft version, I start talking about intellectual property law. I am in a research center where we not only have competition law people, but we also have intellectual property scholars. And when I first started engaging with intellectual property law, I was very naive, right? I thought this law was adopted for the public interest in having better production and having more innovation and creativity. And the law was designed to create those incentives. But when you look at the actual enforcement of intellectual property law, it's about protecting a few powerful people. Even when you're trying to protect artists, the protection is minimal. And it's really about protecting their individual interest against others. And the reason I'm bringing intellectual property to the conversation is because my colleagues were saying, you're doing market definition, but that's the same as what we do, right? I was like, oh, you do market definition? Really naive, okay? And I start looking at what they're calling market definition, and I think, wait a second. This is not market definition. And this is identifying really all the interests of the complainant, but it's not market definition. So market definition in a intellectual property case, in a copyright case, can actually have some of the similar elements that we see in competition law. There's this, question about substitution. What are the alternative products to your product? But the reason this is done isn't to figure out generally the competitive relationships and thus the harm that can occur on a market, but it's to figure out the harm to the person who is complaining. Yeah? If you have a product that is protected by intellectual property, and you can prove that someone else's product is a close alternative, then you can say that that other product infringes your intellectual property. But this isn't about are consumers benefiting, is the market functioning well? It's about, have you, as my competitor, intruded into my territory, and can I keep you out? That's not about the collective interest. Ultimately, intellectual property law is supposed to protect the public, create benefits, but that's a long-term goal. It's where we go in the end, indirectly. But the public interest is not the main kind of analysis in a case. It's the individual interest. And so, in my opinion, that means market definition may be necessary for other reasons in intellectual property cases, but without market definition, the decisions in copyright law would still be legitimate. They would still be achieving the objectives that they're meant to achieve indirectly, protecting individual interest to then go to the collective interest. I'm saying that in competition law, things are different. In competition law, because the collective interest is one of the main parts of the case, you need to define a market as a kind of illustration of how you're protecting the collective interest. Now, I'm not saying there might not be alternative ways to do it, but to me, the market is something we have and should be or could be a good way of proving that in a particular case, the authority has actually looked at more than just the interests of one complaining company or one dominant company or one competitor that we want to protect, but has looked more collectively at the interest of a larger group of people. Okay. So I'm saying that not only is the market an important philosophical context, but it needs to be defined practically. One step back is a question of evidence. I think there is a difference between saying the market needs to be defined and how the market needs to be defined. My kind of proposal or way of looking at it doesn't give an answer to what the method should be, what the right method is. And I think that's something that we're still really figuring out. It also doesn't mean that you cannot sometimes take shortcuts. Do you have much by object per se violations under Brazilian competition law? Yes? Okay. So you could, for example, have a case where it's a per se or a by object infringement, where you basically assume, this is how I explain by object to my students, at least in EU law, you assume harm to the collective interest will occur. You don't need to prove it. So to me, it might be legitimate to not have a full-blown market definition process in a per se case, because there is an assumption of harm to the collective interest, and we're bypassing the need for evidence. But that doesn't mean the market isn't there. It just means that we've taken a shortcut, right? So to me, that's also a very important thing to think about. And then also, and this is interesting, I think, in the discussion about regulating digital markets outside of competition law, there will also be other areas of law or regulation where the market plays a role, but it plays a different role. So this is a very basic kind of scale. I'm sure that it should be much more detailed and much more nuanced. But I'm trying to say that in competition law, we're at the end of the scale, where the harm to the market should be considered in enforcement of competition law, because the collective interest, harm to the market, is part of the analysis. It's part of what we're trying to protect on a case-by-case basis. But there are also areas of law where the market is a rhetorical device, right? Where the policymakers have a reference to the market, have a kind of general idea that we're gonna need regulation or economic intervention because we want the market to work better. But the actual laws they design have nothing to do with the market. Example of this to me is property rights. So property rights are, the laws that protect property rights are designed in order to make a market work, an economy improve, but the market is a rhetorical issue here. You don't have an objective of protecting the market in the actual law that protects property rights. Somewhere in the middle is different types of sectoral regulation, where the market, protecting the market or having a well-functioning market or addressing failures in a market are the objectives of the law, but the rules, the principles have been created and predefined without having to find harm in every single case. So the digital regulation in Europe is a good example of this. You can talk about the market here. So I don't know how many of you know about the Digital Markets Act in the European Union, but there was a big debate about whether we should get rid of market definition because it made the procedures too long and too complicated. And in the end, they mostly got rid of market definition, but if we're honest, there's still a bit of market definition remaining. And so I was trying to figure out, or I'm at the start of trying to figure out, is there a justification for getting rid of most market definition when you talk about digital regulation? And I think there is, at least in the case-by-case enforcement of the law, because the collective interest, harm to the collective interest, is not a part of these cases. So in the European Union now, there are certain obligations on Google and on Facebook not to do certain things, or to, for example, allow interoperability between products, not to use your data across different services. If they breach those obligations, they breach those obligations. The enforcer, the European Commission, does not have to prove that breaching those obligations harmed anything or anyone, was bad for the public. So market definition isn't necessary because harm isn't part of the actual enforcement. But what I do think is that market definition, to some extent, will become necessary to evaluate whether rules like this are actually achieving their goals. Because the public interest, at least in part of the objectives of digital regulation, is the ultimate goal. So to assess whether or not the laws as a whole achieve their goal, you might need to talk about which markets will reach. But that's not about the day-to-day cases. That's in 5-10 years from now, trying to figure out whether the law was a good law, not whether in a particular case the law was broken. And so I think if I'm going to summarize, I think I want to say that I believe market definition is necessary in competition law, maybe not in other areas of law, because we need to know when a competition authority's actions are justified. And competition law enforcement is only justified where it is in the benefit of the public. In Europe, we have private litigation of competition law that comes usually after cases have already been decided by a competition authority, but we also have private litigation where no case existed by a competition authority. In private litigation, you still have to show that there was harm to the market before you show that there was harm to individuals. Because competition law only gives you rights after the public interest has been harmed. This is different from areas like unfair trading practices or consumer protection, at least in Europe. I am sitting next to the Brazilian expert here, where you don't have to show harm to the collective. You just have to show harm to yourself, and that's enough. And so to me, this conversation in Europe at least has been going on and on and on. How do you know whether competition law was rightly applied? How can the competition authority prove, or a court prove, that this was right, that it wasn't an unfair trading case, but it was a competition case? And one of the ways I think we could do is to say, well, was the market defined? And was harm to the market a significant part of the case? But it's a draft paper, and I am very happy to get any feedback and criticism. And in Europe, market definition is in a state of change. We just had revised guidelines, the market definition notice. And there's a lot of discussion going on digital markets, and Nicolo is working on this idea of ecosystems and market definition. So what I am putting forward is like a tiny fraction of the debate on market definition. But for me, this is the foundational basis on which we should work. And all the methodological challenges should relate to this legitimacy question. Okay, thank you.
So thank you so much, Magali. I think everybody here, I could see they are making notes. So probably they're gonna share some ideas that we can, go further in this debate. I would like also to thank, now that you are here, Mateus and Lauren for the support as our academics here. Thank you so much for everything. And first, we're gonna listen to Professor Patrícia Sampaio, that is one of the, in my opinion, one of the brilliant minds that we have in Brazil. And probably she's going to provoke you a little bit. So let's listen to Patrícia. The floor is yours.
Thank you. Thank you. Good morning, everyone. First of all, let me say that it's really an honor and a pleasure to be here. I've wanted that for many years. I did my master and my PhD at the University of São Paulo, but in the capital. And very good friends, professors here, who always told me, you should go there. It's a beautiful campus and the environment. And I wanted first, actually, I've been here before, but online. And now that I've been in person, I realized it didn't count. No, I'm just joking. But I'm really, really, really happy to be here and to get the sense of what a community you have in these very past few minutes that I've been here. You have a feeling, places have a feeling, you get the sense of that you have such a very nice environment to learn and to share, and all this beautiful. I'm really inspired. And I'm really also inspired for being with such people that I admire so much, friends, colleagues, Professor Nicolo Zingales from my law school back in Rio de Janeiro, Professor Vinicius Klein, Professor Juliana, to which I have the honor to have been in many debates before, and also, and most of all, for Juliana for having brought Magali to us, and so that I have the chance to talk about and discuss these subjects that are our passion. I think we share this passion of regarding competition law. One of my fields of study is the interaction between competition law and sectoral regulation, what we call the regulated markets. So I have some insights on that based on your paper. And I'm also very thankful that you had this generosity of sharing a draft paper. I think that anytime you have the chance to read something before it is published, it's really an honor. And please receive my very few comments as a way to show you how honored I am of having had the chance to read it at first, okay? So I think that the first subject is that I fully agree with you. I buy your argument. I think that market definition is key to the proper enforcement of competition law. And by saying that, I am saying that I'm not so convinced so far for all these arguments that try to say that digital markets are different and that we cannot define markets because, you know, you have zero pricing and, you know, data is different from money. I'm really still not convinced, and I think that your argument goes on that direction. And having said that, maybe you could start the paper by putting it that straightforward. Why are we discussing market definition in 2024? I mean, if we went back like 20, 30 years ago, I think that there was a consensus. We had the concept of relevant market. It has a product services dimension. It has geographic dimension. Some people would say that it also have a temporal timeline dimension, but that's it. Why are we now discussing market definition? So I think that as a teaser, it would be very interesting if you could bring it at the very beginning. Why is my paper important? It's important because some people want to get rid of market definition, or at least say it's not so important anymore. Okay? And then I think that the main message of your paper, and it's very important one. I teach administrative law at the undergraduate program at FGV Law School in Rio. So I think that at the end of the day, you were talking about a risk of arbitrariness. And if we are talking about democratic societies, we should be very concerned about administrators, about public officials taking decisions and telling companies what they can do and what they cannot do based on too much discretion. And actually, when we use it to say that, and it's true that antitrust law is the fundamental field for law and economics. It was the very first one, and then we quote the Sherman Act and say, you know, now you have a field of law that only functions perfectly if you have and you know some economics. Why? Because you cannot sanction anyone by abusing market power if you don't know what the market is, and the tools to define the market are economic tools. And I want to come back to that in a few minutes. So we use it to rely a lot on economics for delivering good decisions in antitrust law. And that reminded me of a quotation that you made when you were at FGV in Rio. Maybe you want to go back there when you said that it's not a good time for economists. Maybe it has a lot to do with the paper that you are writing. And because we are concerned about arbitrariness, and because we know that at least in Brazil, it's very clear from the competition law that we are protecting the public interest. We actually say that the purpose of the law is to protect the collective. We actually use the same word as you do But of course, we also allow for private enforcement. But I think, and that's one of the questions that I would like to make to you, is that at some paragraphs of the paper, I got somehow a feeling that you were saying, well, you know, private enforcement is very important, but we have to put public enforcement at first sight. Isn't it the opposite? I mean, because when we talk about competition law, at least in Brazil, we say the ultimate goal is public interest. It's to protect the public order. And okay, once we've done that, then we can, people who were somehow harmed by that cartel or by that infringement may seek private compensation. And I know that I think this is exactly what you're trying to say, but at some passages, maybe it was not, it could be a little bit more clear. For instance, and making a provocation, okay. On page 4, you, at the very end, you say, thus, the use of competition law by a competition authority to pursue individual interests, particularly where they are covered by other laws, may be illegitimate. And my question to you is that maybe, or is illegitimate, or at least should be illegitimate if you were to draft a good competition law. So that's a kind of provocation. And building on that, and maybe, and this is something that you would like to address, is that is it not because you are trying to reconcile two very different traditions, which is the U.S. tradition of litigating in courts and having cases brought by private parties seeking treble damages and so on, and the EU approach, which is very much more similar to the Brazilian approach, which is to have an administrative enforcement branch. And then, of course, you can dispute the decision in court if you think it's illegal or unconstitutional, and you can seek private damages in court once it is cleared that an infringement has occurred. And just like you mentioned in your paper, we do have the individual claims and the follow-on claims. We have both, but the tradition is that you make private follow-on cases because it's very hard at first sight to discuss in judicial courts the existence of a competition infringement. We can, it's allowed by the law, but it's not very much the tradition. And maybe this is just the same of trying to reconcile US and EU backgrounds. Okay, and then, the other thing that I wanted to mention is that, if I'm not mistaken, because I could have just taken it wrongly, when you talk about the regulated sectors, I got the impression that just like in your argument in IP law, that you were saying that maybe we didn't need such market definition so precisely as much as we need in competition law. And maybe because of my background, I tend to disagree on that, because what I did in my PhD was that I looked at the case law of the Brazilian Antitrust Authority, CADE, and tried to figure out cases in which CADE had intervened, either imposed remedies or said that people had abused market power, I mean that there was an illegal action by the companies, although we were already in sectoral regulated sectors. And by saying that, one of the things that I had to do is trying to make a differentiation between a regulated sector and what the markets are, meaning what maybe is very obvious, but one sector, you take the power sector, electricity sector, you have many markets. You have wholesale market, you have retail market, you have transmission power, you have distribution, and this is really legally constructed, because the way the markets are designed in Brazil may be very different from the way they are designed in other jurisdictions. And why is this important? Because the way the competition authority thinks is based upon market definition, relevant markets, and power and rivalry, and so on and so forth. And sometimes the regulated authority wouldn't have the tradition as of seeing the markets in the same very way. It was true for many years in the financial sector, for instance, because the sectoral regulator is more concerned about the risk of contamination of one institution to the others, because they are more worried about protecting the market as a whole. I mean, the healthy of the financial markets. They would be less concerned about improving competition. I think that those days are a little bit over, especially after the crisis, but there used to be this argument. So one of the things that I had to really dive into was in reconciling the idea that, yes, you can see the regulated sector through the lens of market definitions, such as, and this is important because at the end of the day, if you're talking about at least infrastructure markets, which are the ones that I study most, you're talking about price, you're talking about access to the market, then you had to know what the markets are very precisely. Another issue on that, and I'm coming to the end, I promised, is that although these markets, these called regulated markets, they are subject to ex-ante regulation, we try to make an argument that the attributions of the competition authority, they still remain, although these markets are regulated. Of course, this is residual, but the competition authorities can, and actually they do act. We have many cases in the EU case law regarding, what we would call regulated markets, because these people still can violate the competition law. But yes, we have to have some sort of concern on concurrent jurisdictions, because concurrent jurisdictions may lead to opposite decisions. And of course, this would be detrimental to what you are trying to achieve, which is legal certainty at the end of the day. So I think that having the places for each of these agencies is very important, but I think that they will have to, in most jurisdictions, they both have some sort of legal attribution over these markets. And one thing that they should be in agreement with is that what are the markets that we are talking to. So I think that the definition of relevant markets are very important, is still in regulated markets. And as a final comment, and paying some tribute to my friend Nicolo, who is from Italy originally, because now he's almost Brazilian. When I was looking for the definition of the market, the supervisor of my thesis, Professor Campilongo, he wanted me to read the Italians, because the Italians would have very deep discussions on the legal concept of markets. So what is a market under the legal concept? And then I read two Italians that were really fundamental to the way I see things nowadays. One of them is called Maria Rosaria Ferraresi, and she says that the word market can be read in different ways, because you tend to write that the market doesn't exist, that the markets are abstract. Now, I would say that, well, it depends, because you can read what a market is in very different lens. Markets do exist. You can go and buy, and you go to the shopping, and there are places where people interact, even from the medieval times. So yes, there are places, and we can see the interaction between suppliers and buyers reaching out, and the prices just come up. So this is one way of seeing it. There is another way of seeing, which is our very technical approach with relevant market definition, antitrust. Okay. And of course, the markets can also be an ideology. Maybe it's outdated nowadays, but if we go 30 years back in time, we use it to discuss a lot whether we like market societies or we prefer planned societies. So of course, it can be a way of just having some sort of ideology. Part of the society will be pro or against what is a market, would be called a market society. So I think this is very interesting way of seeing, and you don't have to say that markets don't exist. And the final, and maybe the one that was most influential to me is a professor called Natalino Irti. He has a book called The Ordini Giuridici del Mercato. I know my Italian is very poor. I'm so sorry about that. But the basic idea, and that really inspired me and keeps inspiring me to date, is that he says that the concept of a market for a legal scholar is always the set of rules that apply to a certain product or to a certain service. So the basic argument is that there is no such thing as the market for the law. The law we have as many markets as there are the different services and different products, because there is no unregulated market. Even what you would call an unregulated market, it's deeply regulated by corporate law, tax law, maybe IP law, and all sorts of law, and all these rules that applies to that product, and somehow design if that is legal or illegal, how you can sell it, how you can buy it. And I think that this is a very interesting idea to discuss in a law school, how the law has the power to actually define the boundaries of the markets. I hope you can find some of these interesting. And again, I'm very, very happy to be here, very honored. Thank you very much, Juliana, for this lovely invitation. Thank you.
Professor. Professor Patricia, it's our pleasure. I would like also to remark here that we have Professor Jair, our labor professor, and we all know that the labor markets are also a hot topic, right? So Magali, I think you must, give some attention to all these remarks, and we here very, anxious to listen to you.
Okay. Thank you. Those are really useful comments. I'm gonna start with the last one because it's freshest. Thank you for mentioning those Italian authors, because I run a class, so I really agree with you. I run a class for my master's students at Glasgow, which is about all the different ways we look at markets, so economically but also legally. And I don't have any Italian sources, so maybe this is an oversight and I should bring them in. And my students, at the end of the class, only read my first paper, The Antitrust Market Does Not Exist. And they fundamentally disagree with me every single time, which is quite funny, because we spend first hours talking about how, different philosophical conceptions, markets used as ideological, like devices, pro-market, anti-market. But also we talk about how competition law makes markets, and how fundamentally competition authorities, even though they say they just ad hoc intervene when things go wrong, really shape markets more and more, especially in the European Union, where the European Commission now, for better or for worse, is becoming a designer of markets more than it used to be in the past. And so my students also tell me that this idea of saying that the market does not exist is flawed. Right? So it's quite funny to hear it again. And I think part of it is that I was trying to say, in a way, that markets in competition law do not exist because they are like the tip of the iceberg of so much discussion about what is a market, and it is so context dependent. So I will look at the Italian authors. The markets versus marketplace is an interesting one, because I think I have a lot of Asian students, and we talk about how you can walk into like a really big square and it goes on and on and on, and you have all the stalls of identical products, and how this could in theory be an example of a perfect market. But then the question becomes where the boundaries lie, because you know, when I was in one of those marketplaces, I got bored after 3 stalls and I stopped. So for me, in a way, like my personal boundaries were there. So we had a question about how far you stretch. So how do you delimit what the boundary of the market is? Is it that neighborhood, or is it like the core inside? And even there, it's a physical space, but there was no agreement in class about what the market was. And I thought that was quite fascinating, because you would think that there it would be clear the square is a market. So I think it's a really nice philosophical conversation that I love to do, but it has a practical like example in physical places. So I like it. I think the most interesting thing you said was about regulated sectors. So first, I think there is a difference between how the regulation of a regulated sector works and the regulated sector after it's been regulated. And I was trying to think about the extent to which you need the market as a legitimacy point in regulation of particular sectors. And you know what I present here, I don't think it's as clear-cut as how I present it. And I think this is a part of the paper I need to work on a little bit more, because also in telecom regulation in the European Union, we started out with market definition, and then over time, the regulation became, I want to say, more regulatory, less competition-based, because the experience of competition enforcement is what inspired the regulation. And so what they started doing was predefine markets, right? So they made a list of existing markets, which to me is so very different from competition enforcement, where your market varies with the particular conduct you're looking at. But I don't know if it's that clear cut, because those predefined markets had a relationship with existing competition problems. So I think what you're saying is very important, and I need to think a little bit about it, because what I'm doing is very black and white, whereas it's actually a much more gray zone scale. So I need to work on that a bit more. You made a lot of interesting points where I just went, yes, I need to make things clearer. One thing that I really struggle with is I'm not gonna lie, private enforcement of competition law is difficult for me. And it's difficult for me because I think there were multiple reasons why in Europe we got private enforcement of competition law. Some of it was US influence, and some of it wasn't well thought out. Some of it is, you know, when you've got international pressure or the pressure of interest groups to come up with a private enforcement framework, because, you know, they will have more ability to go to court, more work for lawyers and so on. But that was part of the conversation. Another part of the conversation was saying that by private enforcement, you would get more cases, and this would lead to better enforcement of competition law in the public interest. And I'm still not convinced this is true. And I think this is something that I'm still trying to wrap my head around, because with follow-on litigation, I think it's fairly straightforward to say there was a problem, there was harm to the public interest, and now individuals that were harmed as a consequence can get damages, can get redress. But and so this is also very clear for the courts. But when you bring a first action to a non-specialized court, I think it is, especially at national level, I think you see this in France, you see this in Italy, very difficult sometimes for the courts to understand what competition law is really about. So
You can add it Brazil.
Brazil too?
Yeah.
Okay. So you've got these non-specialized judges who are trying to do the best they can, but what they are used to is unfair competition law, unfair trading practices. And so they start from this perspective of you were harmed and you did something, and let's balance those interests, which for me really misses the point. But, you know, there is more and more push for private enforcement. So in a way, I feel like I'm going to be left behind, right? I'm going to stand there waving, going, either we fix this part or we should stop having so much private litigation, whilst everybody else says, Magali, be quiet. private litigation is happening and it's fine. And I think this is it's not just like some people say it's ideology, but I really think fundamentally this goes to the question of what is competition law about and when does it become like a useless tool? Because if we're doing private litigation where really it's about balancing individual interests, we don't need competition law. We've got a lot of other areas of law in Europe that we could use instead. So, but I have to admit that this is something I am still struggling with. And a colleague that I was talking about this with someone really that I really respect, Giorgio Monti, and I could see that he was like, not so sure that I agree with you. So like people I really respect, and I think like me, I hope, might also not entirely agree that the objective of private litigation should be the same as that of public enforcement. Some of it is U.S. pressure. I fundamentally, yes.
Maybe there is a role for what we are calling private enforcement, but meaning that a private company could sue another one if the company is seeking for the stoppage of the conduct. Because this is something that you can do in a preliminary injunction, things like that.
Yes, exactly. As opposed to the damages itself. No, I agree with that. But yeah, you've made a lot of comments that I think are really useful. So thank you.
So thank you both. It was a very good discussion here. And now you're going to listen to Professor Vinicius Klein, professor that is doing a great job in all economics, the competition. We have papers together, work together. So Professor Vinicius, it's a pleasure to have you here, and the floor is yours.
Thank you very much, Juliana. It's an honor to be here again. I think the first time I was here was really a landmark in my academic career. And it's an honor to be here with you, with Magali, that's an amazing scholar and runs the most amazing center in the world, I think, that's Create. And I advise everyone that has a chance to go to Glasgow and stay there for some time. It's the best place to do research, with the best ambient to collaborate and discuss and debate, and very well managed by Magali. And it's a pleasure to be here with Patricia, that is a friend and has shared me. I was with her several times in events, academic events, and I learn a lot from every time she speaks. And with Nicolo, that has been with me also in some events, and also learned a lot from him. And this paper is very interesting. It's a discussion that I like. I'm trying to do some stress some foundations of the paper, maybe some insights that came to me after reading the paper. The first thing I think is not so clear in the paper is the discussion of the concept of substantive legitimacy. Because, and you said in your presentation that you want to avoid the discussion about the aims, the traditional discussion about the aims of competition law. I'm not sure if it's possible, because I think things are a little related. Because like this, imagine that we think about efficiency, maximizing efficiency in a very Posner way of view things. And in this case, maybe you can have, let's imagine that you have a methodological tool, known in advance, in a transparent way, to assess efficiency. And it's not market definition, maybe. And then we can have like transparency, legal certainty, but without market definition. And if you have transparency, legal certainty, why is not legitimate? There is no legitimacy in the way you do the competition. Because when you say substantive, I understand that there is an intrinsic value. It's not the procedure. It's like the value of competition law, of market definition for competition law, for my point of view, I don't know, for my reading, is a little linked to the aims of competition law. Because if the aims are different, maybe the aims are democracy, then you can have like a different procedure. And maybe it's important, maybe I didn't, it's my reading, I didn't see so clearly why the procedure is better than alternative procedures. And one way of seeing legitimacy in the way of law, the virtues of law, or the state of law way of viewing things, is having objectivity, coherence, legal certainty, and things like that. And I don't know if market definition is the only way to achieve those virtues of law. Universality, for instance, the idea that I can have the same rule for everyone. Market definition helps in this way. I think it's the best procedure. But why, like, assessing increasing potential competition is not valid as a way if you can achieve objectivity, transparency, and all the virtues of law. This is like a point that I think is more fundamental. And going into the idea of market that Patricia discussed, I think it's important. The public good we're protecting. And this is some elusive concepts I think we have in, like, the idea that for regulation, for instance, the idea that market failure is a boundary for when to regulate and not to regulate. This is not true. Like, it's a way to, the concept of market failure is important, but it's not a clear and a precise way to define when I want to regulate, when I not want to regulate, I think. It's important in the history of economic thought that when we discover the idea of market failure, but sometimes in legal theory or legal studies, you say, oh, there's a market failure. There is no doubt I need to regulate. No, it's not so easy and simple like that, I think. And the idea of protecting markets, maybe sometimes, and this is, I think, it's a little elusive concept when you discuss it's an abstract or concrete. For instance, I think, and this is going to go to some North American authors, not Italian, but if you go to like critical legal studies, like Duncan Kennedy, for instance, and this tradition, you can have this idea that have some background rules that define capitalism and some foreground rules that make changes in the fundamental way of capitalism. And maybe you try to protect the rules, the legal rules, the institutions of a market, of market dynamics. And maybe this is something that came a lot to my mind when I was reading, because I'll always take it for granted, like you're protecting market dynamics or the process of discovery in a hierarchical way of thing. But I read your paper said, no, maybe you have to put an institutional feature in the way you define what's the public good, because if the markets cannot coordinate by itself, and you need a public authority, as you presented, this public authority is the state, and the state uses laws and institutions. So you're not protecting this natural way typical for classical economics to view market as something that's natural, that came in the world. You're protecting a specific way that passes by the state. And this is, I think, what Patricia said, but using different kind of authors and different trajectory, but it's the same way. And but one point I think is a virtue of market definition, and it's important virtue. It's a tool to assess context. And maybe and I'm gonna go back to the first question. Maybe if I'm trying to just measure efficiency, I lose a tool that allows me to understand the context of this market, not just the final result. But then I think, in my point of view, after reading, maybe one point that could be stressed in your paper is how competition law is context dependent, and the context usually is economics, but could be different tools. And market definition is maybe better. I don't know if I'm right, but maybe better because it not just allows transparency, legal certainty that you could have maybe in other if you know by advance other methodological procedures. But you also have a way of assessing the dynamics of the competition and the context. And maybe if you just measure like efficiency after, or if you just measure potential competition or fairness after you do, like do an intervention 5 years after you do a cost-benefit analysis, and you say, okay, DMA was a success because it increases efficiency or innovation and increases potential competition. But how we got it right? How we understand the context of the market? You don't need to do that. You just need to figure out the results, because the aim of the law is not necessarily protect a specific procedure, but protect innovation or protect potential competition. Then I think this is a feature that is presented in your papers, but could be stressed here more. For me, it's a way of buying more this argument of substantive legitimacy and not effectiveness. Because one way to say, and you showed also that some other branches of law use a market definition. It's not the same procedure, but define market in a more broader way to say, oh, I achieve my goal, like for effectiveness. But for legitimacy, maybe they don't use that. And the idea, and also, and finally, I think your paper, and I talked to today more, but is a good point, can be a good way to discuss DMA, because I think the discussion that per se rules are not competition rules in essence, because they don't analyze effects, they don't understand the market dynamics or their regulation, and the discussion that DMA is regulation or competition law or something like a hybrid between both. This could be putting more light, I think, if you understand why you need to have a specific context in each case, and the best tool to assess this context, as you know, at least until now, is market definition. And then I think can be a way to improve, in my point of view, the paper. And one final point is the role of transparency in your argument, because market definition can be a way of legitimacy, but let's imagine that you have a different method for digital markets to define market, define markets to relevant markets, and this method is very obscure, and people don't understand how this method works. It's still gonna be legitimacy in competition law. For instance, if this method is very hard to access for companies, for society, or maybe for community of scholars. But one of the things I think, and another thing that's good for market definition is that a little straightforward method. Of course, when you go to the case, it gets more blur, it's harder to apply, but when we teach competition law, we teach like basic steps of market definition. And the students that are paying attention, not working their cell phones and things like that, they can understand what's the main steps of market definition. And maybe if I make a very hard method, a very difficult method for digital markets, I lose this. And this is not, maybe this harms legitimacy of competition law. I don't know if you agree.
Okay, thank you, Professor Vinicius. We didn't mention in the beginning about the create that you are heading as a director is very interesting place for you, especially the students, because it's super innovated, right? Because it's just like having different minds from different fields. And of course, nowadays, it's very important to face, the differences that we have in the markets when we have innovation. And also when you deal with competition law, it's super difficult even for the authorities to deal with some cases when we have innovated, markets. And I think this is the core of our discussion here, basically after those comments related to Vinicius' points. So this is something that I would like you to share. Of course, I think I need to go to Glasgow, not only because I really appreciate the work you're developing there, but of course because we have very good whiskeys. So this is something very important. But
and good mountains too.
Okay, and mountains, okay. That's why we were talking about mountains. And everybody was just like, okay, in Brazil, maybe beaches. So now you can, try to comment and also, of course, answer some points here that Vinicius just shared for us. Thank you, Vinicius, again.
Yeah, so everybody come to Glasgow. The Create Research Centre where I work, it's a mix of competition law, regulation, IP, but also economists, cultural policy scientists, historians. So we bring all these people together and we look at like the big challenges of digital and creative industries, always from multiple perspectives, which is both really fascinating and horrible, because I realize most of the time that I know nothing. It's a very uncomfortable situation to be in, but it's good. It challenges me. And for things like innovation, like Microsoft buying Activision Blizzard, like for our center, that was suddenly, wow, like everyone is involved. We were all sitting around the table and talking about this because, competition was like 10% fraction of what was really going on in the industry. So come to Glasgow. We also do master's programs, but we also do a lot of research on fun events. So come have whiskey. To Vinicius' comments, yes, you are absolutely right. I cannot avoid the question about objectives because ultimately that's what this is about. But I am sick and tired of the question about objectives because we never agree, right? Like, how many PhDs have been written about the objectives of competition law to ultimately have another PhD 2 years later? It's just, and I think fundamentally what I was trying to do, and it's a bit weak, like it's a coward's thing to do, but I was trying to say, look, even if we're not sure whether it's efficiency or total welfare or consumer welfare, ultimately, the reason I think that we fundamentally all agree that it's about the collective interest. But you will see that that's only one paragraph in the paper. And every time I look at it, I'm like, I know that the first question I'm going to get is one paragraph. You should have more on the objectives of competition law. So you are right, Vinicius. I'm afraid that the debate then becomes massive again, but I have to do more. I cannot avoid it. So thank you for calling out that I was a coward. But to your like related question about if we had a tool to assess efficiency directly and it had transparency and it gave legal certainty, would it be a good alternative to market definition? And I think fundamentally, my argument is no, because there are multiple areas of law that are meant to lead to more efficient industries or more efficient markets, right? But that is a result of, and this is a very European perspective, of protecting a market. Now, in Europe, at no point did we ever agree that efficiency was the goal of competition law. At no point, right? It is one of the things that we think will happen if you protect the market. It's also an argument you could bring in a case, right? You could say, well, maybe I'm excluding competitors, but they were inefficient. But that's to show that the competition authority isn't just randomly choosing companies to protect. It's not because efficiency is the main goal of competition law. And I think there is a nuance there. And this is my interpretation of the jurisprudence in the EU, but I think I am right. I usually think I am
but
right.
this is, this is the aims of competition law you're discussing.
But that's, I know, thank you. Like you forced me to do this, right? You forced me. You put me in this position and I am doing it. So yes, you're right. I need to talk about this. I need to talk about the aims of competition law. But I think efficiency or any other thing, ultimately, my question is, what are the boundaries? Why do we have competition law versus another area of law? And efficiency cannot be the answer to me because other laws protect efficiency. So yes, I will have to engage with the conversation and I will do it. And I mean, your question about what is the public good is like a really big question, and it's fundamental for what I'm arguing, I think. But again, it's so difficult to encapsulate it in one piece. But you know, when you asked about transparency, I think you know that to me, transparency is incredibly important. It's why I wrote the first article I wrote, because I think, well, it's one of the reasons I wrote it. One of the problems I think we have with market definition is that although the methodology that we present to our students is straightforward, in actual fact, it becomes basically economists fighting and spending hundreds of thousands of euros or reais, or convert in your brain, basically to make this, what seems like a simple methodology, a complicated exercise. And to me, that is problematic. To me, that's a problem. And I think we are currently not very good at transparency because some countries are better. I mean, I think it's easier to find what is happening in market definition in US cases than it is to understand what happened in the EU in a decision by the European Commission. Freedom of information requests on market definition, and I have tried, they end up with, well, you know, we discussed the companies, therefore it's protected, it's confidential information, so I cannot give it to you. Or if I give it to you, I black out 99% of what is in the decision making. And then I look at it and I think, well, this was pointless exercise. Why did I do a freedom of information request? But this, I understand why, right? I understand why the European Commission cannot give it to me. Because there is so much confidential information, not just about the parties, but also about the economists who are paid so much money to make like a 5% different argument than the other economist. But that means that the process isn't transparent. And I think this is it's not really what I'm saying in the article, but it's related. It's something I think we need more transparency in the market definition process in Europe, particularly. I really think so. I do not think we can have a really legitimate system without more transparency. But this is not something I'm gonna solve overnight. But I think it's a very, very important question. And you know, I said it earlier too. I agree that I could do far more in the paper to talk about digital markets, the Digital Markets Act in Europe from a different perspective, and add to the debate. The debate in like Europe now is, I want to say, 75% Digital Markets Act. And everything else that remains is labor markets, which is cool, or sustainability, which is cool. So I'm like trying to do a market definition thing when everybody else is talking about other stuff. It makes me uncool. So maybe by bringing in more DMA, I'll be cool again. So yeah, I'll do it. I'll definitely do it. Yeah.
Thank you. Great paper.
Thank you, Professor Magali. Thank you again, Professor Vinicius. And last but not last, or last or not least, we have here Professor Nicolas Ingales. It's so great to have you here in person. It is a pleasure for us also to hear you. And we all know here in the university that you are doing a great job as a researcher, especially in digital markets, right? So the floor is yours, and I hope you can, bring us additional comments after those amazing comments from Patricia and also Vinicius.
Yes, thank you. Thank you very much, Professor Juliana. First of all, for the invitation. It's an immense pleasure to be here. I don't know if it will be easy to follow up with additional comments after this very interesting remarks that were offered. So I must say it's a pleasure also to comment on this draft. As you were saying, Magali, this is closing the circle. Somehow we are going back to where we started our discussions, and that's great because it means that you know there are issues that are not solved by any manner. They're becoming, if anything, more relevant now. I think with the new wave of legislation that we are witnessing, not only in Europe, also in the UK, and now probably in Brazil, regarding digital markets. And so I think taking the suggestion that was offered here at the end, I will devote my comments to that part. But I also want to acknowledge the pleasure of complementing the comments by my friends, Professor Patricia and Professor Vinicius, that were excellent. I think I'm in agreement with everything that was submitted, but mostly everything, because when you say that. I take a comment from Professor Patricia that digital markets are not that different. You know, that then here is where I think this was a trigger for me. Yeah. Okay, so I will not go in depth into discussing all the characteristics of digital markets because they are quite commonly discussed. But I think what we are confronting here is an issue that refers to a switching of the unit of analysis from a narrowly defined market to a set of markets that are somehow all ensemble put together in the terms of ecosystems. And so I need to make maybe a little explanation of what we mean by ecosystems. So basically, ecosystems is where you have a multitude of players that offer joint value to consumers. And they are related in a way that is not hierarchical. So that means that you are not, as an ecosystem controller, what we call the orchestrator of the ecosystem, you are not dictating within your value chain how the value is being created in a manner that is similar to the classic production chain, where you have a number of suppliers that give you the raw material, and then you are basically at the top of this value chain, and you direct this raw material. You maybe reassemble it, and then you bring it to the final consumers. Here, it's more like a joint value creation because you provide an infrastructure, you provide the digital platforms, like it could be an app store, it could be a social network, and then there you have multiple parties that are acting on top of this infrastructure to provide some value to the final consumer. And of course, the ecosystem orchestrator can in some way steer the creation of value in one direction or the other. And it does it through the standards, the technical standards that allow the interconnection with the platform, as well as the terms and conditions that it imposes to the developers for the operation of these services. But in that, the challenge is how much of the value that is being created goes to the ecosystem orchestrator, and how much goes to these third parties that benefit from the infrastructure. So how much should the orchestrator get in return for this infrastructure? And to what extent, when they get a high percentage of the value that is being created, this is a value appropriation that should be the subject of the economic regulation, the control by the economic regulator. And so here we go into the area of more like private disputes over, you know, who is more entitled to a share of the pie, and it's not the classic analysis that we have in antitrust, over, how our consumers benefit. Maybe if we agree that it's consumer welfare, we can discuss for hours what is the final goal, but you would agree that there is a concern for what the final, the collective, the group of consumers is getting in return, and not so much for the dispute between the trader and the infrastructure provider. So you can get into disputes between the trader and infrastructure provider, but those are looked at from the perspective of if this relationship is repeated with several players that are in a similar situation, then this will lead to detrimental effects on consumers. And this is not necessarily the logic that we have in these digital markets, where we want to really adjudicate disputes of value creation and value distribution. So this, I think, it's the new paradigm, is the new challenge that we have here. So why is market definition in digital markets different? First of all, there is this interconnectedness of players and interconnectedness of markets. So it's not just by offering one type of product that you can see all the picture. There are multiple markets that are related. So in many markets where we navigate online, we have one side, which is very often the paying side, and then you have another side that is for free to consumers. So you need to take into account the dynamic of this, and this means that you have to look broader. But in addition to it, you have situations of dependence, because this locus where competition is occurring becomes more and more relevant as it brings together different players. So you cannot very easily switch and move to a new environment. So we are no longer talking about the market as a way to assess market power in a broad sense of general market power, but also relative market power, because a player needs to go through the other in order to offer services to consumers that player might not be offering in himself. And so there is a concern for protecting the relationship with this party from which you are dependent. So there's this. There's informational power that can be used through interfaces. So in physical marketplaces, you can have some architectural design that encourages, for example, consumers to buy more junk food when they are waiting in the line of a supermarket. But in digital markets, this is done much more prominently, much more frequently. There's several ways in which consumer can be steered. And so there is a concern about this manipulation that I think is more significant. And here, so there's this aspect of informational power that I think should be taken into account. Now, I don't think I exhaustively addressed the topic of why digital markets are different, but just I wanted to offer these few reflections before I move you to your claim, which is in the context of legislation like the Digital Markets Act, the market definition is not an essential element. In fact, it's not a piece of the legislation, it's not explicit that is relevant in this legislation. But the legislator has the onus of showing, maybe in a few years' time, that markets have improved, because that's the final test over whether the legislation is properly applied and should be revised. Now, I think that claim is definitely true when it comes to contestability, which is one part of the goals of the Digital Markets Act. So here also to brief everybody up, there is the side of contestability, which means that this legislation must allow the new entrant to overcome the barriers that exist in core platform services. So a number of few important platform markets. The other side, the other objective of this legislation is fairness, which is defined as basically a balance between substantive rights and obligation, meaning that there cannot be too burdensome conditions for the players that are operating on top of these markets. And here I think it's more difficult to say that in a few years' time we should look at whether markets are competitive, whether market is the relevant unit of analysis here. It seems to me that we are more interested in ensuring that the constitutive conditions for a thriving economy, digital economy, are present, which is not necessarily looked at by analyzing market by market, but it's more like a general welfare concept, which I think can be independent. So I don't know if in that part of the claim I agree, but definitely on this side we are much closer to the individual, as I was saying earlier, to the individual dispute type of scenario than the collective. And so I don't know if that would turn that aspect of the Digital Markets Act illegitimate for you. I would be interested to hear your elaboration on that. Now, when we are talking about these constitutive conditions, implicitly we are referring to an ecosystem that, in order to thrive, needs to have in place certain safeguards, and this brings to the fore the importance of looking at not just market failures but ecosystem failures. So when we are talking about the case of Apple versus Epic, famous case that is about the extent to which Apple's conduct is abusive when it does not allow the developers like Epic to just tell the users that they can purchase services outside the App Store. They can go on a website and they can buy the same product for a lower price, possibly because they are not subject to the fee that Apple imposes through the App Store. And here what Apple is using as a defense is that they cannot guarantee the security of products that are purchased outside the ecosystem. So here, the goal that they want to promote here is security of the ecosystem. And if you look at the individual transaction, maybe you do not understand, you do not capture what are the dangers that can come from acquiring something outside the ecosystem. On the one hand, you are maybe concerned about security, but on the other hand, you're also concerned about giving Apple a sufficient incentive or sufficient reward for the moderation that they're doing in the whole ecosystem. So not just when it comes to the market for games that is at stake when it comes to Epic. It's a more general issue of the App Store that they don't want this to happen in any type of market. So this will set an example if they were to allow steering of users to external sites that could have an impact on the ecosystem as a whole. Maybe even if in this specific case, it wouldn't, right? So this logic is more like looking at the ecosystem welfare or ecosystem failures. And I think this is what we are going to see more and more often. And in this context, we will have more also of a dialogue, I think, between authorities, because the objective is not so clearly only an economic one. At some point, so we are talking about security here. You could invoke privacy reasons. You could have issues of content moderation, and so there needs to be a dialogue between the authorities to understand these ecosystem failures, and this is going to become more and more common. But at the same time, we are talking here about economic regulation. We cannot allow basically the economic regulator, which should serve the collective interest, to turn these private disputes, into into more rules of more general application. So one challenge here is that you have many provisions in the Digital Markets Act and similar laws that are very difficult to comply with. It's impossible, basically, I would say, to comply perfectly if you interpret literally every provision of these laws. So this opens a huge path for any company that is interested in to operate in digital markets to go to the executive body, the European Commission or the competition authorities, and say, here they are violating a provision of the ex-ante regulation of digital markets. You should fine them and you should set this precedent so it doesn't happen anymore. And these are maybe disputes that you can also bring to private litigation in every member states of the European Union, or in the UK, or in the future in Brazil. And well, the legislator would give more credence to this argument, to these claims, by authorizing what would be more properly private disputes in the context of public enforcement of ex-ante regulation. So I think on this claim, it is a little bit dangerous. We should think seriously when we want to create a new legislation about what is the role of private enforcement, because it was already pointed out here, like in the European tradition, private enforcement is maybe not so strong as in the US context, where 90% of the litigation comes from private litigants. So to what extent are we distorting competition law by creating channels for what would be more properly private disputes to become precedents or rules that everybody's concerned with digital markets should have in mind as a reference, and so they will try to comply in line with these dynamics that are more private. So I think your paper should point in that direction, or one suggestion is that we should be careful about that, about mixing these two, because the dynamics, the incentives are different. And I want to suggest as a way to make it more sexy and more no, because it was pointed out, you said I want to bring the DMA to make it more sexy. Well, you have a perfect case there, which is the TikTok designation. So TikTok, there were two issues. It was designed as a social network, and they were claiming that actually they should have been designated as a video sharing platform instead. And here it's pretty arbitrary, I think, the way it's conducted right now by the European Commission. They put you into a box, but you don't have much of a way to overcome this. So I think this worsens the situation from the point of view of the message that you send to all those that are operating in multiple markets, all those that are present, ecosystems that are multi-present in these markets. Maybe just to be sure, they should comply with all the rules applicable to all these ecosystems, and this is problematic. The second one is the fact that they refer to them being basically not a fully fledged ecosystem. So they are just a newcomer, they are just a challenger of the incumbents. That would be probably Instagram and Facebook, the social networks. They are the new social network, and therefore they should not be designated as a gatekeeper, and they should not be regulated as such, because that would encourage them to grow, and they would allow them to get more power, and then maybe at some point later they should be designated, but not for now. And well, here, if you try to look at the relevance of the market in the Digital Markets Act, I was looking at the text. You can find some hooks to bring in this argument. It didn't fly in this case, but let's have a look. So in the designation, there are three elements. One is that the conduct the gatekeeper has a significant impact in internal market. So here we have an explicit reference to market, but this is another type of market, as also Patricio was saying, and the Italian scholar was saying. It's not market in the sense of the locus of competition. It's a market in the sense of the whole European Union commerce. So what's the impact on this type of trade within the European Union? So that is not helpful for us. The second one is it provides a core platform service, which is an important gateway for business users to reach end users. And here, basically what is used as a parameter is the number of active end users passing a certain threshold of 45 million per month. And here again, we don't manage to fit the market concept unless we try to link the users to a context of market and not category, as the European Commission does when it puts into boxes. So maybe here there is some leeway to say, as a rebuttal, one could be entitled to bring the market here to the initial categorization that the European Commission does. Maybe you can through this second element. But then the funniest, I think the most interesting is the third one that says it enjoys an entrenched and durable position. It doesn't say in the market. It's really on purpose, right? It just says it's a position. And differently from the German legislation, which says explicitly a position across markets, here it leaves it open. So it can be that even a position within a specific market is sufficient, whereas in the legislation in the Germany is explicitly focused on this broader ecosystem concept. So not the first one that makes the point here. I forget his surname, Philip, starts with H, is a German name, PhD at the Berlin with Heike Schweizer, I think, with the late Heike Schweizer. Yes, so he had a paper saying that the ecosystem concept is not incorporated in the digital markets legislation. I think this is probably accurate if you read it with a literal assessment, but if you are optimistic, you can try to incorporate the ecosystem arguments. And there's a recent paper by Jasper van den Boom that tries to suggest a way to do that in the process of designation. Well, there's one element in the DMA where they say that the European Commission, when enforcing the legislation, should take into account the conglomerate position of gatekeepers. So that's the way that you can try to read this. And also as a way of rebutting, so saying that actually somebody is a gatekeeper, even if it does not meet the presumptions that we just mentioned, that we did not mention, but they are related to these three elements that we mentioned. There is a reference to a conglomerate corporate structure or vertical integration, for instance, enabling data taken to cross-subsidize or combine data from different sources or to leverage its position. So I think there are some passages there that can allow us to bring to the fore the relevance of the ecosystem. And here you could try to use the TikTok case as an example of why this legislation can be dangerous. It can harm markets if you don't take into account this kind of challenger positions. And this is only the designation process, but you can also suggest that every single provision that applies to the gatekeepers, the way in which it is interpreted, in which it is applied, should be linked to the market somehow, and maybe as a way of combining both the market and the ecosystem, you should always have both views, I think, at the same time. So you should protect the market, the narrowly defined market. This is something that if you don't do, there's a risk that the DMA really goes against competition legislation, or a DMA or equivalent goes against the competition legislation. But at the same time, the added value of this legislation is precisely to look at this broader concept. And so maybe what you can try to do is to try to use this case as a way to find arguments that would enhance both the collective interest in protecting the consumer's individual market, but also protecting a collective interest when adjudicating these disputes between orchestrators and complementors. And that is not easy, because you need to understand how value is created and how it's properly distributed in a way that satisfies your condition, which is the collective interest, right? And so I think we have a challenge before us, but you definitely provide some food for thought. And yeah, maybe let's try and think together. It's a huge set of challenges, because understanding just how the market works, it's complex. Understanding how this is relevant for the designation process is another challenge. And then understanding how it would inform the obligations for gatekeepers is a third challenge. So I don't think that today we're going to solve those, but I'm happy to contribute to this discussion, and thank you for the opportunity.
Thank you, Professor Nicolo. All this discussion here, just remember when I was defending my PhD. So you may fight for your paper, Magali.
I will fight. No, but I think ultimately a lot of what you say overlaps with some of the concerns I have about Digital Markets Act and digital regulation. When I first saw the Digital Markets Act and then saw how the designation process was being done, I actually started writing a paper about market definition in the DMA, because market definition was being done at the first step of the process. So they engage in determining what the existing products are and categorizing, but they never do a proper, transparent, rigorous, robust analysis. And so before I wrote this, and I ditched this paper, before I wrote this, I wrote about bad market definition. And then I thought, well, maybe ultimately the question is, maybe the market definition is bad, but is that a problem? And so this is how I got to the legitimacy question, right? Is it a problem to have this kind of, so do we need a proper market definition process for legitimacy? And I think about the DMA, you're absolutely correct. The two parts, right? The contestability versus fairness, they are completely distinct. And you make a very good point. Like what I'm saying about in 5-10 years from now, we're going to evaluate how good the DMA was at achieving its objectives by reference to relevant markets. It can only be for the contestability part. The fairness part is difficult for me, right? As a competition academic, difficult for me to reconcile with the way I see the world. But maybe the way I see the world needs to change. But what I really, this is me just being conservative, I think. I just want to at least protect competition law, right? And take those things like fairness and value distribution and say they need to be somewhere else. To me, it's actually quite satisfying that the question appears in a different regulation, because what I first started being concerned with is the fact that in Europe, not only do you have EU competition law, you also have national versions. And in some of these national versions, abuse of economic dependence, relative power, is an element of the provisions. And that, to me, sat really uncomfortably with the way I see what competition law is supposed to do. But before digital markets, it was less of a problem, because even say in Germany or in France, the abuse of economic dependence provision can only, as a competition provision, be implemented if there is harm to the market, which makes it pretty much unenforceable, right? Because again, like the standard there is so incredibly high that it's not abuse of economic dependence that's enough, there has to be harm to the market. And this is where I started saying, well, there is also abuse of economic dependence provisions, distribution provisions, fairness provisions in other areas of law, like unfair trading practices, and they are far more easy to prove. So in most of the cases that were successful, and I'm mostly pre-digital markets, the success came from using unfair trading practices, and the abuse of economic dependence and competition law was thrown in for good measure, but it wasn't the thing that made the case succeed. The Digital Markets Act turns this a little bit on its head, where relational power, relative power, becomes such an important aspect. But to me, that's exactly the point I'm making, is that means we need to be able to determine the boundaries between what is value distribution, what is not about the collective interest in the market versus what is about the market. But I don't think we have the answer yet, because I think the DMA is confusingly written, to put it mildly. And how it's going to be implemented is going to be even more confusing. And for some of the contestability things, I think we really are going to be looking at markets. Like assessing their effectiveness of those provisions is going to be about markets. But for fairness, I don't think that's the case. So I think you're absolutely right, and I should make that clearer. When we come to the fun thing, the ecosystem thing, I think, and maybe this is me just really wanting to fit everything in the market, but I think it's just another way of talking about markets at a different layer of analysis. And so fundamentally, I think this raises the question, when we're talking about a new type of power, architectural power, or informational power, are we talking about a power that has an impact on a group of people, a collective? Or are we talking about something that is a one-on-one relationship? If it's about a collective, it's about defining the ecosystem and finding ecosystem power as kind of a more advanced way of reasoning about markets and the connection between markets. I think it fits squarely within what I'm arguing. I think, to me, the next step of the analysis of market definition is going to be talking about ecosystems as a more advanced way of defining markets. But I really fundamentally think it's a methodological question, not a fundamental question. I think it becomes a fundamental question, like about the foundations of the law, when it becomes a source for regulation that's really about, as you say, the one-on-one relationship between Apple and Epic. And that is uncomfortable, really uncomfortable. But it might be uncomfortable because I'm just stuck in my ways, a competition academic, not willing to change or adapt. And I've said this before, right? I've told you this before. I said it in Rio. Like to me, digital regulation in Europe is no longer about competition, or at least no longer about competition alone. It's about the way we see the world and how we want to shape the world. And that's not something that I'm used to as a competition academic, right? In my classes, for the most part, I don't go and ask my students, what's the future that you want to see and how do we get there? I think the DMA is about getting to a particular result, and it's not clearly articulated what that future is that the European Union wants to see. But to me, that's very different from intervening in competition law on particular conducts because it harms the market. That's not those interventions in competition law, no matter how much we talk about innovation and future markets and dynamics, those are still quite short-term interactions and interventions. It's very different from creating the Digital Markets Act is part of many regulations. It's about a group of regulations. Very different from adopting a group of laws to completely reshape the way digital society works in Europe. That's what that is about. And TikTok is a good example. So I am engaging with the designation decision. I think I need to put it in. I think you're right. But TikTok is a good example because we now talk about the designation as a gatekeeper under the DMA, but it's under another regulation, the DSA. It has now decided to withdraw part of its services from the European Union because its services do not comply with that regulation. And I think most of the reports I've seen about it were happy. They think TikTok is a bad influence, and I agree. But that's different, very different from intervening on a particular conduct, right? You're basically saying this whole service that you have is bad. We don't like it. Get rid of it. Very different. So I think you and I and all of us, we need, as academics, we have a very important task now, which is to kind of hold to account what is law, right? What is law? What are the foundations of law versus what is basically a grand design by a state authority, or in the European Union, a supranational authority. And that, I think, is what digital regulation now is in Europe. It's a grand design, it's a planning exercise. And I think academics, students, all of us need to kind of talk about what are the limits to how much we would allow a government to plan a society. But my paper is not going to solve that. But, you know, it might talk a little bit about what I think is legitimate and what I think is not.
Okay, Magali. So I was not here to, give more, comments, but I just would like to hear a little bit from you, because I think there is a geopolitical, yes, background, and this is something that is very clear for us here in Latin America, right? Where you can see the difference between the authorities in EU, and you compare to United States, and now United States is changing. So I would like to hear a little bit, because we were inside the exciting, airplane talking about this recent movement, and then of course we are here in the academic, room. We can share ideas. And as someone that lives in UK, I think you can, also share your views for the students here. I would like to thank you, Professor Andrea, for coming. And of course, you also can, give comments back to Magali before we just finish. But if you can share a little bit about this geopolitical moment that we are facing, I think it's very important.
Yeah. Being in the UK is fascinating, like really fascinating. I'm an EU citizen in the United Kingdom. The United Kingdom left the European Union, so it has freedom, in theory, to do things differently. And it's also adopted a digital bill, but the digital bill has more of a competition flavor than the EU's bill. There is reference to market power, markets, harm to consumers, all of that is still in there. So even like close to each other, there's already some divergence in how we see what should be happening to make the world better. And the US, so what we're referring to is the US just had a judgment saying that Google in fact is an illegal monopoly in its search engine. We don't know what the next steps are going to be, and I'm going to be very honest, I didn't read the 280 something pages yet, but we don't know what the remedies are going to be. But it's still a very classical competition analysis, right? Even though there's more of an ecosystem flavor to it, we're still seeing classical, there is a market, there's a monopoly, there's harm to competition discussion. What is changing in the US, I think, is that now they're openly talking about breaking up a company like Google. But breaking up companies is not, it might seem radical, but it's not radical, it's happened before. And I think that's different from saying we're gonna create a authority that becomes the shaper of a market, right? You might break up a company because you think there's a problem, but then you're supposed to let those the new parts run. That's very different from having a continuous monitoring of how these companies design their conduct, design their business model, design their products. And I think there is a broader question that's beyond competition, which is about the role every part of the world is now playing in this. And I've said it before, but I will repeat it. I think the European ambition is to be the one that sets the standards, right? And in digital markets, that means the standards for the world, I'm afraid. Unless you get fragmented services, like I've got Chinese students, they don't use the same services as I do. Different digital companies, but even if they use the same services, they get a completely different experience because they have a digital wall between their services and our services. That might be the only way you adopt different approaches across the world, is to wall them off. And that is not a future that I want to see, right? I think the benefit of these services is that it allows us to talk to each other, right? Without me having to pay loads of money on a landline to call you, email and WhatsApp, they allow us to communicate with each other. But if we're not going to wall them off, then what are you doing? Here in Brazil, you're talking about digital regulation. What will that digital regulation look like? Will it just be a copy-paste of Europe? And if it's not, if it's like the UK, which is not a copy-paste of Europe, will it be effective? And I've said this before, and I will repeat it. I am not sure the UK model is going to be able to make much change, at least not on big things, maybe on the margin. Because I don't see a world in which the services are still effective and regulated differently across the world. I didn't think coming to Brazil, this was how the repeated message I was going to give. I really didn't think so. But being here, I keep thinking about it as like a crisis for lawmaking and democratic policy making across the world. Because the territorial boundaries for these things, at least, are not so solid. So if you want to be part of the conversation, you need to regulate now. Like in the next 6 months, you need a piece of regulation. I doubt that's going to happen. But if that's what you want, then I think you need to be part of the conversation immediately. Especially if you want to do something and offer a solution that might improve on what the Europeans are doing. I feel like every time I talk now in Brazil, I end up on a negative note. So I don't know. I don't know what the positive note is. The positive note is that it's a really good time for academics and anyone who wants to like engage in the conversation. This is your time to shine. Yeah, this is the time when you raise your voice and you write papers and you try to make a difference. There's going to be lots of work going ahead, but where does that leave us internationally? I guess we have to cooperate more. That's the positive? Yeah. Sure. So can somebody say something positive now?
Well, I think besides everything you said, here in Brazil, we have a second question. Who is going to regulate? You know? But let me open the space here for, the students, if they want to share some ideas or ask some questions. We have also students online. I think Tadeu is online and maybe he can tell us if someone wants to share. So we have now, it's weird, right? It's in the... Yeah. But here we are in the free space. So if you want to, just raise your hand.
Pressed everyone. No one wants to talk.
Yeah, no problem. Otherwise, we're gonna have this final moment when I can give the floor for the professors. Then you can make your final comments. Okay, so can we start with Professor Patricia?
I guess that the final words, besides saying thank you very much, Juliana, thank you very much, Magali and Vinicius and Nicolo, is that we are not, when I say that I really think that we are still talking about the dynamics of markets as we use it in the physical world. I think that most of the things that Nicolo puts very precisely, we can still reframe it in the sense of a traditional competition thing. We have two-sided markets. We had shopping centers before. We talk much more about barriers to entry, but in regulated markets, we always talk about barriers to exit. Franchise agreements are a very type of thing that you are tied for 20 years after you sign a franchise agreement with the public administration. So I think that the very difficult question is that we still don't know how to answer the things, and we haven't actually talked about it. It's that net externalities. They have a very good side, a very positive side. Everybody wants to be where everybody is. Yeah. But we know that with net externalities come market power, and with market power comes negative outcomes. And I think that we are still in between. So I think that would be my final comment. But I mean, you can write many papers. You don't have to solve all the problems in only one. Keep some of the problems for the next papers. So thank you very much, Juliana. Thank you very much, Professor Magali.
Thank you again, Professor Patricia. Just to mention that during this month, I got not only the support from Mateus and Lauren, but also Veronica, Kyra, Mariana, Fernanda, Beatriz, you're all here, so thank you so much. I cannot live without my students, you know. They are great academics. So now I will give the floor for Professor Vinicius.
So I want to thank you very much for the opportunity. It's a great paper from Magali, and very insightful to talk with Magali all the times. And it frames the questions, the important questions, in a very insightful way. I think that's very good. And for me, like, this is maybe a positive side. I started to think as market definition as a more interesting thing after reading your papers. And before it was also good, but now it's a more urgent and pressing issue in the end of the discussion for me. Thank you.
I would like to mention that we have many professors around this huge country sending good messages about your presentation and about this discussion here. So just to let you know. And then now I give the floor for Professor Nicolas Ingales.
Okay, thank you. So I have the honor and the burden of being the last one. First of all, I did not say it at the beginning, how wonderful the campus is, and I'm very grateful for the opportunity to see it. I was already here in 2016 online.
Yeah, online, yes.
When it was not cool yet being online. There was no Zoom, it was very Skype.
You're right. It was before the pandemic, right?
Yes. But no, really fantastic to be here. No, it was a very interesting discussion. I think we have all now some tasks for us to think about how to reframe some of these concepts, how to link them to the traditional economic regulation that we're used to. Patricia closing and saying that I put the things precisely, but then she went against what I said. So I like it. No, it's true. So I did not want to say, and also responding to what Magali suggested, that market definition is impossible or shouldn't be done in digital markets. What I wanted to say is that it's more challenging. That's why we need a new framework, maybe to have closer monitoring of certain aspects and more capacity to understand value creation and value distribution, for example, but also what the market failures are and ecosystem failures. So having this double look that was suggesting maybe can be a way of resolving this conflict. But looking at the specific market failures, maybe we can shape our legislation in accordance with that. So, for example, if information asymmetry or manipulation is one of the big concerns, then a transparency obligation can already solve it, and we don't need to go the full extent of an ex-ante regulation as in the DMA. If the problem is, for example, with this one of dependence that is created by network effects, maybe just an interoperability obligation solves this problem. Then you combine these two and specific remedies that address the specific problems that we identified. So it's important that now, especially in Brazil, that we are thinking about how to structure this. We look at what are these failures and why competition law is insufficient or incapable to address them precisely. But what we need also, considering what we are saying, is to understand the vision of society that we want to have, but also we need to have transparency from the regulator. So when market definition is used to define which categories you fit a certain ecosystem into, and you don't say it, but you are actually engaging in this market definition. Let's be clear. Let's create the guidelines saying, how you establish this, how you can rebut it, and what's the relevant metric that is used. Probably alternative metrics that can be used to define the locus of competition. So that's important. And the big question that also was raised is the competition between authorities. So who regulates? Maybe that's a way to set apart some of the more vague concepts and say, well, this should be for another type of regulator. The competition authority, I think in Brazil especially, there is this debate, and it is better placed than any other authority to enforce ex-ante and digital markets regulation. But maybe some aspects of it will be necessary to, consult another authority or find a procedure by which the competition authority can simply use existing frameworks and still apply their tools and don't invent completely. I don't want to say that inventing or being creative is bad, but what we need is an underlying structure that allows us to predict how it's going to be applied. And some of these concepts are new. So closing on a positive note, we can help to define, delineate these concepts. We can help by suggesting also a way to create this dialogue between authorities. I think these are the big challenges. I'm happy that we have a good group of scholars that can work towards that. So thank you, Juliana, for organizing this. It was very valuable.
Thank you so much, Professor Nicolo. In fact, I need to thank also my department, because not only because, of course, I had the support, the financial support to bring you all here, but also by the fact that they approved me to leave and to meet you when we were together as American Bar Association. It was like 2018, right? It was before the pandemic, but we had this opportunity to stay together inside the program that they have, international scholar for international scholars, and I think it was a great opportunity to know more about your work that now is very well known. I just would like to mention to you all that yesterday I saw a paper from Commissioner Vitor Fernandes, and his paper is from, the main topic is adapting market definition to digital markets, lessons from CADE, but he used all the papers that you have. So it's amazing that here in Brazil, of course, I think it's just like a picture that your work is very important for us. So thank you so much for sharing your ideas. Of course, I'm giving you the floor to end this session, but I really would like to thank this university to giving me the support to do things like that. This is an open space, and I really enjoy the fact that not only my department, but also my special friend Gabriel Lochagin, he's not here. I really miss him here, but he was the one giving me support to stay in Brasilia. So I am here inside a space that I have not only great professors, but great friends. And here we are also friends. So thank you so much for coming.
Wow, what can I say after that? I have enjoyed this whirlwind tour of Brazilian competition law, and there's much more to see, so I hope to come back. But I really am grateful to have come, because I feel that there is a dynamism, a kind of optimism and hope for the future that, despite all the challenges you have here, that I really needed, right? I needed to be around people that were like, yeah, and we can move things forward, we can do things, and there are challenges, but let's fix it. And sometimes when, I'm in the EU or I'm in the UK, I get really bogged down on the details of the regulations, and it becomes almost a bit repetitive. And I think I needed to be around people who were like, yes, this is good, right? Let's do this. And Thank you. This has been really inspiring, the whole trip. And Juliana, like, thank you so much for putting it all together. It's been so impressive. Like sometimes, and especially everybody who was in like the WhatsApp group trying to get things done, sometimes I would open my WhatsApp and think, oh my God, and put it back down and think, I'm just gonna follow. I will follow. And like the work to get me here and to get it all organized, really impressive. Thank you so much.
Thank you. So thank you all. For you that is still here, then we're going to take a picture, of course. For the others online, thank you so much for following this discussion, and now the session is ended.